Do you have DACA? Or perhaps you just want to know what's going on with DACA. Or you might be interested in what's going on with the 3 and 10-year bar policy with immigration. Well, this video is for you. My name is Jorge Molina. I am an immigration attorney based in Dallas, Fort Worth, and serving clients worldwide. And today we're going to be talking about DACA and the 3 and 10-year bar change in policy. Okay, so throughout the years, we made several updates regarding DACA, and I always say this is one of my favorite immigration benefits, not because of the benefit itself, but the people it helps. And today, finally, we're able to announce what we've been waiting for many years, which is the implementation of a new regulation. Importantly, it's not only about the new regulation, but it's about the ongoing litigation that we have. And I'm also going to use some of the time to talk about the 3 and 10-year bar change in policy. I don't want to make it too technical, so I'm going to give you a few examples of how the change might help you or a loved one. And if you have any other questions, you can always reach out. But let's start with DACA. So if and let's talk about it in the context of the litigation. So when DACA came out, there wasn't really any litigation and it was just sort of accepted. However, when the Obama administration announced the DACA 2 policies, different states are suing the government, arguing that the government had violated the APA, the American Procedures Act, that requires certain changes to go through the rulemaking process. So that was the crux of the argument. That was the central piece of the arguments that the states were making to the courts. And, very, very astutely, states picked their venue, right? So they're suing in Texas mostly. So this, DACA survived the Trump administration. And the Biden administration came in and said, well, we're going to fortify DACA and we're going to protect the dreamers. We're going to protect people that have DACA. And the way that we're going to do this is that we're going to create a new rule. All right. Well, we've been waiting since President Biden was elected for this rule. And finally, we have it. In essence, the rule codifies the DACA standards, right? So an individual must have been under 30 years old when the first DACA was announced. So born before June 15th, 1981, or excuse me, after, had been under the age of 16 when they entered the United States, have lived continuously in the United States since at least June 15th, 2007, finished high school or currently in high school, be over 15 years old when they apply for DACA, and among other things. So like no disqualifying felony convictions or significant misdemeanors or a series of other matters that were provided as a directive under the CIS policy. So in essence, this regulation codifies DACA. It's a standard. Unfortunately, they didn't really expand who's eligible for DACA, but at least those that do have DACA are protected. Now, this new regulation comes in, well, it was announced about 30 days ago, and it's going to become effective October 31st of this year. So in about 45 days, it's going to be effective. So what does this mean? All right, so if you currently have DACA, this means that very likely you're going to be able to continue renewing your DACA application, and that if there's a change in administration, the program will likely remain for a long time unless a new administration goes through the rule changing process, which it's very long, it takes a lot of effort, and often it can be invalidated through the courts if they're trying to dismiss a set rule. So DACA is fortified. It seems it's here to stay for now. But where does this leave other people that currently don't have DACA or could have qualified for DACA? or individuals who had DACA in the past but can't renew it because of an injunction from a court in Texas. So here's where litigation comes in. All right, but so let's simplify it. The arguments that the states were making where, well, the government violated its own law by not following the rule-making process. So in essence, that's what Texas and Louisiana were arguing to the court. Now the federal government goes to the court and says, you know what, we have solved this issue. We have a new regulation. So the case was pending at the Fifth Circuit, which is the circuit that covers Texas, Mississippi, and Louisiana. And the court just recently, about 10 days ago, required both parties to make arguments on how, this new rule changed the litigation. So the argument that the federal government was making, well, the argument that the states were claiming is gone because now we follow the process. Here's the rule. But the states are still arguing, well, we're still injured by this program. This was an overstepping of the federal government. This should be a law, cannot be a regulation. They are changing the argument because of the changing in circumstances. So we're not sure what the Fifth Circuit Court of Appeals will do. My bet is that they're going to side with the states. And frankly, this is not a position that's just based on the rule of law or the letter of the law. It's clear that now the states' arguments are moot. They're no longer effective because they created the rule. So they're considering new things. So maybe they send it back to reconsideration in light of the rule and look at other arguments, or they just side with the states, issue a ruling, and then the federal government would appeal to the Supreme Court. Now, I think, and unfortunately, we're at a point that courts become more and more politically active. And I do hesitate to say that because that's a big argument. But this is the trajectory, and based on oral arguments and the way that the Fifth Circuit Court of Appeals was addressing the federal government and pushing on certain things, it seems that there's a political angle here. It's no secret that before you're nominated to a Supreme Court, some judges are judges in the Court of Appeals. For example, Justice Alito is a good example. He was actually in the Fifth Circuit before becoming a Supreme Court justice. So this is a very real possibility that they're just trying to issue in a way that pleases conservatives. So, I'm not holding my breath for a favorable decision, but it could happen. However, if there's an unfavorable, either way, if there's a favorable or unfavorable decision, it's very likely that this case is going to end up in the Supreme Court, and the Supreme Court would issue a ruling beginning, in the first few months of next year, if they take it for the fall session, which is, it's about to start. But yes, that's what's going on with DACA. DACA is here to stay. However, we're still pending. We're still waiting on the pending litigation. So we're waiting on that. So what does this mean if you have DACA? If you have DACA, you can continue renewing it. If you had DACA in the past and it lapsed for over 1 year, you cannot renew it based on the injunction issued by the district court in Texas. And then if you would have been eligible for DACA, if under the new regulations, we're still waiting for the Fifth Circuit Court of Appeals or even the Supreme Court to issue a final ruling to see if this is going to help us or not. So stay tuned. This, and broadly speaking, this is very good news because we finally have a regulation, but we're still waiting on the courts to issue a ruling. On the other hand, now let's talk about the 3 and 10 year bar. Here's this is just good news, and it's a very welcome change in policy by CIS. But really to understand how it benefits us and you know and the benefit of the changing interpretation, let's examine the problem. Right. So there's a punishment created under the immigration laws that says if you are in the United States without any lawful status for over 1 year and you leave the United States, you cannot come back for 10 years. That's known as a 10-year bar. There's another punishment that says that if you're in the United States unlawfully for 6 months or more, but less than 1 year, and you leave the United States, you cannot come back for 3 years. That's known together as a 3 and 10-year bar of inadmissibility. But here's a problem that this change in policy resolved. And, you know, consider the following hypothetical, all right? So let's say John entered the United States with a valid tourist visa from Canada. So in the year 2000, he's here in the United States. He falls in love madly with this girl, and he decides to stay. So a year later, his girlfriend breaks his heart, leaves him, says she can no longer be with him, and she goes to Mexico. Then John, who is still very much in love with his girlfriend, goes to Mexico following her. And at that point, he leaves the United States and he triggers a 10-year bar. But what happens? John is in Mexico. He speaks to his girlfriend. He realizes it is over. We can no longer be together. And he understands that. But he wants to go back to the United States, right? So John goes lawfully back to the border, shows his Canadian passport with the tourist visa that he had in 2001. And the immigration officer doesn't ask any questions, just lets him back in. So right there, the immigration officer should have said to him, well, you cannot come back for 10 years because you triggered the 10-year bar. But the officer, for whatever reason, didn't do that. And he has a lawful entry back into the United States. Okay, so, and we're going to talk about more about the legal repercussions of here, because now, you know, we're within the United States, but we were subject to this bar, 10-year bar. So what happens now? Well, John continues working and living in the United States, and his girlfriend comes back to the United States, has a child. It was his child, John Jay. About 6 months later, she calls him, tells him, I can't raise John Jay. I'm going to give him to you. This is your child. And John raises John Jay by himself. John is an excellent father. John Jay has a great relationship with his father. And it's 2022, and John Jay wants to get his father a green card. John was still in love with his ex-girlfriend, and he never remarried. His parents are long past. He has no other relatives in the United States except his son. So here's the problem that we had. So in that case, where John Jay is filing for his father, who entered lawfully to the United States, whose bar of inadmissibility was triggered when he followed his girlfriend to Mexico and had that 10-year punishment, right? So the problem that we had in certain jurisdictions is that whenever John would apply for that green card through the son, the immigration officers would realize, oh, well, you triggered the 10-year bar. You need a waiver, or you need to wait 10 years outside the United States. That was a policy that immigration had in some jurisdictions. In others, they interpret it, in my opinion, the right way, in which they said, well, that punishment, that inability to come back to the United States was for 10 years from the moment that you left, and continue running, whether you're in the US or in another country. But, and the importance of that interpretation is that the law doesn't require him or a person who triggered it to be outside the United States. And then another punishment right under it says that if you triggered this other problem, if say you entered unlawfully, right, instead of going through the border or through customs, you would be unable to come back for 10 years. And by the way, you need to apply for a waiver outside the United States before you're coming in, right? So that's what it says right underneath. But in this case, the law doesn't require that. So the argument that we were making before immigration and courts is like the interpretation of immigration is unreasonable. There's no requirement that you need to spend the 10 years outside the United States. It can just be 10 years. So let's look back at the case of John Jay. Now, before the change in policy in a jurisdiction like Dallas, immigration would have said, well, you trigger that 10-year bar and you have lived in the United States continuously during the last 20 years. So you need a waiver. But the problem that John would have in that case is that he has no qualifying relative. The only relative that he has is his U.S. citizen child or son, John Jay, and he wouldn't qualify him for that waiver. Only a spouse or parents who are U.S. citizens or lawful residents would. So here, John Jay, has a son and everything. It's been over about 20 years since he triggered the bar, but they were imposing this punishment at that point. So that was before. Now the policy, which is, a very welcome change nationwide, says that no, that 10-year bar started in 2000 or in 2001 when you left, and it ended in 2011. So there's no need for a waiver. And in that case, John can get the green card. So a lot, of facts here to explain this. It's a very welcome change. It's, it's closer to what the letter of the law says. So, immigration did a good thing here. So folks, if you have any questions about the 3 or 10-year bar, you have DACA, or you want to know some more about this, subscribe to our channel. We're constantly updating you about these matters. Follow us, give us a like, maybe share, maybe comment in our videos, or you can also follow us in Facebook. And if you have any questions or you'd like to talk to us directly, you can always send us an email at info@jmolina.law. This information is also given to you in the credits. And you can call our office number 469-708-5800. Again, I'm Jorge Molina. Thank you for watching.